Welcome back to the second segment of Contract Law Remedies. Now, before the break, of course, we were discussing the extent of damages, and certainly we looked at the categories in relation to damages and how the courts have approached it. Now, in this segment, we want to start off with looking at the methods which limit damages. Now, there are three broad methods of limiting damages, and these include, of course, the remoteness rules, which we touched on briefly before, the causation rules, and we would also consider the breach in the context of it having caused the loss, as well as what had been preceded before. So we're looking at remoteness rules, we're looking at causation rules, and we're looking at mitigation. So if you look at mitigation, for example, the plaintiff has a duty to take reasonable steps to mitigate his loss. What does that mean? Well, we will consider all three, remoteness, causation, and mitigation, in that order, or not necessarily in that order. Let's start off with the easiest one. Let's start off with causation. Well, the first thing about causation is the loss must be because of the breach. You will touch on something similar when you do tort law, if you're doing it this year, or certainly if you come to do it next year. But the loss must be because of the breach, whatever the loss is in contract. Of course, case in point, of course, is Monarch Steamship Company and Housen. Now, this is a 1949 case in the House of Lords, Monarch Steamship. And in the case, the claimant purchased a quantity of soybeans to be shipped on the appellant's vessel. Now, the vessel was the British Monarch. It was going from Japan to Sweden. Now, after the cargo had been loaded and the journey commenced, the British Monarch developed problems with its boilers, which caused considerable delay in the shipment. Now, the terms of the charter, the terms of the contract, the appellant was to provide a seaworthy vessel, and thus the problems with the boiler amounted to a breach. Now, during the delay period, war broke out, and the Monarch was ordered to unload in Glasgow. The claimant arranged for the cargo to be shipped to Sweden and brought a claim against the defendants to recover the costs. Now, the defendant claimed that the outbreak of the war broke the chain of causation. The court said, no, it didn't. The court said that the outbreak of war did not break the chain of causation, since the defendant should have foreseen the possibility of this occurring, and any delay of the voyage may result in diversion of the vessel. So you need to establish a causal link, even within the context of the contract between the parties, before you can recover damages. Equally, the damages must not be remote. So under the rules of remoteness of damage, which is set out in Hadley and Baxendale, a claimant may only recover losses which may reasonably be considered as naturally arising from the breach, or those which may reasonably be supposed to be in the contemplation of the parties at the time that the contract was made. Now, the case of Hadley and Baxendale itself is not terribly remarkable, but the facts are these: that the crankshaft from at the claimant's mill broke. Now, he engaged the services of the defendant, and the defendant was to deliver the crankshaft to the place where it was to be repaired, and to subsequently return it after it had been repaired. Now, due to the neglect of the defendant, it took some 7 days later to have come back. The claimant was, of course, unable to use the mill, and of course, he lost profit during that time. The defendant, of course, said that he was not aware that the mill would have to have been closed during the delay, and so the loss of profit was too remote for him to be tied to that, or for him to repay that. Now, with contract, we're looking at loss of profits. That's fine. As you will see in the law of tort, generally you're not going to get lost profits unless, of course, you're looking at maybe negligent misstatement. But the rule here in contract is that you can certainly recover for loss of profits. Now, in the case, the court said that the damages available for breach of contract included: 1, those which may fairly and reasonably be considered arising naturally from the breach of contract. So if it is something that flowed from the breach, you can recover it. The court also said that you can recover such damages as may reasonably be supposed to have been in the contemplation of both the parties at the time the contract was made. Now, the court said also that if there were any special circumstances which were existing and which were actually communicated to the defendant, the claimant may recover any damages which would ordinarily follow from a breach of contract under those special circumstances being communicated. Now, the application of this principle can be seen in the following 3 cases. First case, of course, is Victoria Laundry Windsor Limited and Newman Industries in 1949. The claimant purchased a large boiler for use in their dye and laundry business. Now, the defendant was aware that they wished to put it to immediate use and knew the nature of their business. The delivery of the boiler was delayed in breach of the contract, and the claimants brought an action for the loss of profit which the boiler would have made during the period in which the delivery was delayed. The claim contained a sum for a particularly lucrative contract which they lost due to the absence of the boiler. The court said that the claimant could only recover losses which were in the reasonable contemplation of the parties, which included the loss of profit that could be expected from the lack of use of the boiler. But the claimant could not recover for the loss of the exceptionally lucrative contract since the defendant was unaware of this contract. Now, the point is, had the defendant known, then the defendant would have been liable. And that is really a crucial point because, again, in an exam question, if it is wide, you need to tie it down to say that, is it that the defendant was aware that this was going to happen? Because if it was, the defendant would be liable equally. If it is a special or a particularly different or exceptional circumstance, then of course he needs to know in order to be able to be liable. Second case, of course, is Pilkington and Wood in 1953. And in that, the claimant purchased a house which had a defective title. Now, shortly after the purchase, he obtained employment elsewhere, and so he needed to relocate. He, of course, had difficulty in selling the house precisely because of the defect in the title. Now, he brought an action against the solicitor for his negligence in failing to notice the defect. The courts held that the solicitor was liable for the difference in value between what it was worth without the defect and what it was worth with the defect. So you're looking at the difference in price. Now, that is usually a good indicator that you're dealing with a damages calculation in contract, is where you can do that sort of exercise and get a set figure. However, the court said he was not liable for the added loss which was caused by the need to move, as it was not in the reasonable contemplation of the parties that he would move so soon after the sale. Again, it would be a special circumstance which they would not have known about. Now, in respect of another limitation, mitigation, the claimant is entitled to sue the vendor. They said, although the court held there was no duty to sue the vendor in order to mitigate the loss arising from the defendant's negligence, in the same case that is. Now, in third case, Parsons and Utley and Hingham, 1978, the claimant pig farmers purchased a food storage hopper from the defendant for the storage of pig feed. Now, the hopper was installed negligently, and the lack of ventilation caused the pig feed to go moldy. As a result, many of the pigs contracted E. coli and died. Now, the claimant claimed over £36,000 in respect of the loss of profit, vet bills, and other costs which related to the death of the pigs. Now, the defendant contended that this damage was too remote, as it was not in the contemplation of the parties that the poor ventilation would cause E. coli and therefore the death of the pigs. The court held that the death of the pigs was a natural result of feeding the pigs moldy food, which would fall within the first limb of Hadley and Baxendale. There was no need to consider whether the death by E. coli was in the reasonable contemplation of the parties under the second limb. So the idea, of course, is that when you look at Hadley and Baxendale, it does give you two routes that you can seek to determine which is relevant. It could be that they could both be relevant, but you first look at the natural consequence, and of course you then look at the whether it's within the reasonable contemplation. Now, the test of remoteness only determines entitlement to damages. It does not look at the quantum of damages, which is the amount. It just looks at whether or not what you're claiming you're entitled to claim. It doesn't say that you're allowed the sum total, because you'd probably be looking at an unliquidated assessment of damages by the court. The same case that we've just looked at, certainly the Utley case is one to consider. But that decision there can also be contrasted against the case of Victoria Laundry, again, a case that we mentioned earlier, because there the court said that the loss of profit on some exceptionally lucrative dyeing contracts were too remote, and they did not manage to get it there. But when you look at the case where the courts are saying, well, no, as far as the pigs are concerned, we are quite happy for the claimant to recover, but certainly look at the Victoria Laundry case, which the court said no to. We will take another break, and on the return in part 3, we will consider what is the duty to mitigate your loss as a claimant in contract.